A thief who enters your house and gets bitten by your dog can sue you for compensation and damages. Now, watch this video, and after the video, I will continue my conversation with you today.
A 19-year-old man died in a car crash after stealing a vehicle with mechanical defects, and his mother later received $1.8 million in compensation after suing the car's owner. According to court records, the vehicle involved was owned by Daniel Thompson, whose car inspection had been expired for 9 months and whose braking system was later confirmed to be faulty. Despite knowing about the mechanical issues, the car had not been repaired. Surveillance footage later showed 19-year-old Jordan Williams stealing the black vehicle late at night, unaware of the brake failure. After taking the car, Jordan attempted to flee the area and became increasingly panicked, accelerating to approximately 90 miles per hour. As he approached an intersection, he tried to slow down but discovered the brakes were not working. Traffic cameras captured the moment the car slammed into a brick wall at high speed. Jordan was not wearing a seatbelt at the time of the crash. According to the medical examiner, the violent impact caused catastrophic internal injuries, including organ rupture and a fractured spine. Police arrived shortly afterward and pronounced Jordan dead at the scene. 2 days later, Jordan's mother filed a civil lawsuit against Daniel Thompson, arguing that the owner knowingly allowed a dangerously defective vehicle to remain in service with an inspection long overdue. She claimed Daniel's negligence directly contributed to her son's death and initially sought $3.6 million in damages. The judge ruled that Daniel had not authorized Jordan to use the vehicle and rejected the claim of intentional wrongdoing. However, the court determined that Daniel still bore 50% responsibility due to his failure to maintain the car and repair known safety issues. Ultimately, the judge ordered Daniel to pay $1.8 million to Jordan's family. Do you think this ruling was fair?
Well, I know you are amazed because last week I posted this video on my Facebook platform and many people passed several comments which prompted me to come and make this video today. I realized that Ghanaians think that this law is quote-unquote a senseless law, or this case is a senseless case, and they don't believe in their wildest dream that this can happen in Ghana. Well, I'm here to disappoint you. This case that you believe is very wild can actually happen in Ghana. Let me tell you why. Article 11 of our 1992 Constitution lists what we call sources of law for Ghana. The sources of law includes common law principles, and a lot of these common law principles continue to operate in Ghana in several aspects of our law. Now, there's a branch of law called torts, T-O-R-T-S, torts, law of torts, okay? Now, under the law of torts, we have what is called negligence, and under negligence, we have what is called occupiers liability. Now, are you wondering why a lot of people put the notice in front of their house and say, beware of dogs? Well, the reason is simple. If you do not have that beware of dogs in front of your house, and a thief enters your house, and the thief gets bitten and damaged by the dog, that thief actually has the right to sue you for damages because you did not warn him that there's a danger in your house. Okay? Now, under the occupiers liability principles, a person who is in possession or who is in control of a particular building is supposed to ensure that his actions do not harm a neighbor. The question is, who is a neighbor? A neighbor is not just somebody who lives by you. According to the law, the neighbor is actually a technical word, and that technical word means that anyone that in your contemplation can come into contact with you or can reasonably come into contact with your activities is a neighbor. And so a thief is your neighbor according to this principle, because you can reasonably expect that a thief may be coming to your house, and that is why you bought the beast known as a dog, so that the dog will protect you. The law requires you to make that thief aware that there's a beast there, so that next time when he's coming there, he will be very careful. Now, if you don't do that, what happened in this video can actually happen to you. Now, what will shock you is that under the occupiers liability principles, there are a list of persons who are protected by the law, and this list of persons includes unlawful visitors. Now, the question is a thief a lawful visitor? The thief is certainly an unlawful visitor. He is trespassing. You have not given him the right to enter your house. Meanwhile, the law says that even unlawful visitors can sue you for damages if they enter your property and something happens to them and you did not give them notice of the presence of that thing on your compound. Now, I'll give you just about 3 cases to illustrate this point. The first case I want to talk about is called Bird versus Holbrook. It's an English case that was decided in sometime 1920. Okay. Now, what happened in this particular case? The defendant was a flower farmer. He had a tulip farm, and people were stealing his tulips. So what did he do? He set up a trap known as the spring gun. In Ghana and in Ekwapem, where I grew up, it is called agao. It's a special type of trap that when you step on it and you are not careful, your leg can be amputated because it's very, very, very powerful. Now, this defendant set up this spring gun in his flower farm because people were stealing the tulip even before they are ready for him to market, to harvest them and go and market. Now, the plaintiff was also rearing some birds, and one of these birds flew into the tulip farm. So he was chasing this fowl to go and retrieve it and send it back to his compound. Unfortunately for him, when he entered the flower farm, he got trapped into the spring gun and got very seriously damaged. He sued the owner of the farm under the occupiers liability principle. The owner of the farm came and filed his defense that, look, this man is a trespasser. I did not invite him to come to my farm. I put up that trap there to protect my flowers because people are stealing my flowers. However, the court said, look, to the extent that you did not post a notice there to tell other people that there's a spring gun on your farm, you are liable. Therefore, the defendant was made to pay damages to the plaintiff in that case. Okay, and it is the same principles that operate in our tort law in Ghana. Okay, now what is the other case I want to talk about? This one is Excelsior Wire Rope Company Limited versus Callan. That was also decided in the English Court of Appeal in the 1930s. What happened in this case? The principle under this case is simply that an occupier must refrain from doing anything reckless that will harm a trespasser. And so once you are in charge of the building, you are the one controlling the building, you should refrain from doing something that will harm anyone who is even trespassing on that particular land. Now, the final case I want to talk about is Moulton versus Pultier. In this case also, the principle I want to share with you is that the courts are saying, do not create a danger to trespassers without giving them warning. So this video, this controversial video of the guy who went to steal and then his mother went and sued the car owner. Perhaps if the car owner had written on his car that my brakes are not good and I've not renewed my roadworthy for the past 9 months, maybe the court would have given him free immunity and he wouldn't have paid any damages. But to the extent that he knew his car posed danger to the public, he left his car without fixing the brakes, he did not renew his roadworthy, and he left his car in a place that someone could have access to steal the car, then the man is liable. This is the Weekly Law Digest. If today is your first time, I encourage you to like, comment, and share this video, and let's continue to connect every Friday to discuss some of these important matters. Thank you very much for watching.